The government has introduced 3 bills to replace the core laws, that is the Indian Penal Code 1860, the Code of Criminal Procedure CRPC 1973, and the Indian Evidence Act IA 1872, which form the basis of the criminal justice system. The Bharatiya Nyaya Sanhita bill will replace the IPC. The Bharatiya Nagarik Suraksha Sanhita bill will be in place of the CRPC, and the Bharatiya Sakshya bill will replace the IA Indian Evidence Act 1872. Significance of these will be, as these bills replace the entire acts and are not merely amendment bills to fix some gaps, they provide an opportunity for an overhaul of the laws underlying the criminal justice system. The Bharatiya Nyaya Sanhita bill. IPC Section 420 deals with cheating and dishonestly inducing delivery of property. However, in proposed Bill 2023, there is no Section 420 and the offence of cheating is covered under Section 316. IPC Section 124 was dealing with sedition. In proposed Bill 2023, the Section 124 in the proposed Sanhita relates to the offence of wrongful restraint. The word sedition does not exist in the proposed Sanhita. Offences of the nature described as sedition in the IPC are covered in Section 150 of the proposed Sanhita as acts endangering sovereignty, unity and integrity of India. The Bharatiya Nagarik Suraksha Sanhita bill will deal with the following: greater use of technology, trials, appeal proceedings, recording of depositions including those of public servants and police officers, may be held in electronic mode. The statement of the accused too can be recorded through video, conferencing, summons, warrants, documents, police reports, statements of evidence can be done in electronic form. Second one is communication devices. The bill adds electronic communication including communication devices to the provision on summons to produce a document. On the directions of a court or police officer, a person is required to produce any document and now devices that is likely to contain digital evidence for the purpose of an inquiry. Next one being mercy petitions. There is a provision on procedures for the time frame to file mercy petitions in death sentence cases. After being informed by jail authorities about the disposal of the petition of a convict sentenced to death, he or his legal heir or relative can submit a mercy petition within 30 days to the governor. As such, if rejected, the person can petition the President within 60 days. No appeal against the order of the President shall lie in any court. Second is sanction to prosecute. A decision to grant or reject sanction to prosecute a public servant must be reached by the government within 120 days of receiving a request. If the government fails to do so, the sanction will be deemed to have been accorded. No sanction is required in cases including sexual offences, trafficking, etc. The Bharatiya Sakshya bill contains provisions as following. The bill makes electronic or digital records admissible as evidence, thereby they will have the same legal effect as paper documents. Next, it repeals 5 existing provisions of the Evidence Act, modifies 23 provisions, and adds 1 new provision. Next, the bill proposes amendments to 23 sections and contains 170 sections in total. Next, in the bill, the scope of expansion for secondary evidence to include copies made from the original by mechanical processes, counterparts of documents, and oral accounts of document contents has been done. Next, through the bill, the government is aiming to introduce precise and uniform rules for dealing with evidence during the trial of cases. Now question arises over updation of gender-related offences, and for that, the bill is in line with the Supreme Court judgment which struck down the offence of adultery. Section 377 of the IPC, which was read down by the court to decriminalize same-sex intercourse between consenting adults, has been dropped. Consequently, the parts retained by that judgment, including rape of a male adult and bestiality, have also been removed. However, it has been noted that some provisions overlap with special laws. Those are: the IPC was enacted in 1860 as the principal law specifying offences and penalties. Since then, several laws have been enacted to deal with specific offences. However, the IPC and the bill to replace it continue to specify some of these offences and the applicable penalties. This leads to duplication as well as inconsistency across these laws. In some cases, the penalties are different. Also, a person may face prosecution under different laws for the same action. Even this bill codifies the procedure for mercy petitions. However, there is no codification of various directions of apex court related to arrests and bail. Some provisions retained the structure, such as maintenance of public order and the process of criminal prosecution in the same law as such. The CRPC has provisions charting out the process of arrest and trial as well as items such as Section 144 that empower the district magistrate to impose various restrictions. The new bill retains this structure.